Good morning, everyone. Thank you to everyone who has joined us already. We'll be starting with the workshop in 2 minutes as it gets to 10:30. I just want to check our presenter, Advocate T, if we can just check that your mic is working and you can see the screen.
Hi, Melissa. Thank you. Yes, I can see the screen. And is my mic working?
Yes, we can hear you loud and clear. Thank you
you.
very much. We'll be ready to start in just a minute. I see there's already 92, 93 pupils who've joined us, which is great. This session will be posted to YouTube, so if you miss anything, you can go and listen to it again. But please make sure you've got a pen and paper in front of you, make notes as we go. You will be able to ask questions. We just ask that you write them in the chat box. If there's anything that you want to know, please write them in the chat, and we'll try and answer questions if we have time at the end of the session. But please take time now, grab yourself a pen and paper, and we'll be starting in the next minute as it gets to 10:30. Thank you very much, everyone. Good morning, everyone, and welcome to this exam preparation session for the pupils who are writing the competency-based exams to be admitted as advocates. These exams are set for 11, 12, and 18 September. Anyone who is writing the conveyancing and notary exams, you're in the wrong session. Your session is later today. So this meeting is only for those candidates who are writing the exams to be admitted as advocates, the exams that are set for next month. Please note that registration for these exams has now closed. So no late applications can be accepted. So please don't ask in this session if you forgot to register. How do we do a late application? Unfortunately, we can't, and you'll have to write the exams in March of next year. So please make sure that you have your confirmation of registration letter that has been sent to you from the LPC provincial office. Please check that it's got your name, your ID number, your exam number on it. It will also include the venue, the times for the exams, as well as all other exam information that you need to know. So please make sure that you have received that letter. If you have registered but haven't received it, you must follow up with your provincial office because you need to print that letter and take it with you to allow you to enter the exam room. For this session, we're going to ask that you keep your mics off as well as your cameras. We know that some of the colleagues in the session are connecting using their phone or data, so using cameras is going to slow down their connection. Also, we want you to keep your microphones off. Because this has been recorded, we don't want any disruption of the recording as well. So let me start with the introductions. As many of you may know, my name is Melissa Murray. I am the Senior Manager for Education and Training based here at the Legal Practice Council National Office. With me in this session are also some of the officials and colleagues from the LPC offices, both national and the provincial offices. And I'd also like to introduce Advocate Nicholas T, who we have asked to assist with the facilitation of this workshop for you today. So the purpose of this session is to go through the information that you need for the upcoming exams and to assist you with how you need to prepare and what you need to do going forward so that it gives you the best chance you have in the upcoming exams. The only thing you cannot ask me today is what is coming out or any of the questions, because you know that we cannot share with you. But if there's any general information that you need, you can write that in the chat and we will assist you. We'll assist you with that information. So the exams are not meant to trick you in any way. The exams are very straightforward. The questions set out exactly what it is you need to answer. And you need to demonstrate your competence in these exams. Remember, they are competency-based exams. The LPC needs to be able to certify that you are competent to enter the profession as an advocate. So the exams are not here to trick you. You need to apply what you have learned, as there's a mix of theory and practical application in the exams. After you've learned the theory, you need to know how to apply what you have learned to a set of facts or even a scenario that's presented to you. But please remember, we need to test that you are competent. That is the bottom line here. Before we get into the documents and before I hand over to the advocatee, just a few notes that you need to remember. For the exam, all 5 exams that you're going to write, you need to have your original ID. So please, if you're making notes, please write that down, original ID. You cannot bring in a photocopy or a certified copy. You will not be allowed in. It needs to be an original document. If you don't have an ID, they may allow a driver's license, but again, it must be an original, the original card, but please try and take your ID in with you. And that's for all the exams. You will be turned away at the door if you don't have your registration letter sent to you from the LPC, as well as that original ID. Unfortunately, there's nothing I can do to help you on the morning or anyone else. We cannot let you in. And this is for security, but it's also to ensure that the person sitting in the seat writing the exam is the pupil who is registered for that exam. So please, original ID, make sure you have that with your registration letter. Secondly, please remember that you must write only in black ink. No pencil, no different color pens. Some of you like to write headings in red or green or purple or blue. That's not acceptable in these exams. You must write in only black ink. So leave all your other color pens at home. The reason for this is that our markers, when they mark your exam, they use red ink. When your paper is remarked, they use green ink. When it's moderated, they use purple ink. So our team who are going to assess your paper use all those different colors. So if there's writing in your exam that is in different colors, we don't know whether you wrote it or whether it was written by one of our examiners or moderators. So to be safe, leave all your colors at home, leave your pencils at home, because you will not be able to write in pencil. It will not be marked. Okay, so that's the second key point there. Also, Tipp-Ex or correction tape, leave it at home as well. Anything you mark, you write and then you cover it with Tipp-Ex and you write over it, you cannot, it will not be marked. So if you write over Tipp-Ex, we will not mark it, we'll cross through it. So please also leave your Tipp-Ex at home, bring only black pens, and just if you make a mistake, cross through it and then carry on with your answer after that. Please read the instructions on the question paper. You do have sufficient reading time. Have a look at what is asked of you. Write only on one side of the page, that's the right-hand side, but it is the side that has the lines. So make sure you only write on that side in black ink and don't use your Tipp-Ex. That's what I need to share with you to make sure that your paper gets marked. If you write your whole exam in pencil, we will not, you'll get 0. You know, unfortunately, rules are rules. We cannot mark anything other than black ink. All right, so before I hand over, I just want to take you through the 2 documents that you would have received. You'll see that there is a notice that was sent to candidates that are registered for the exams, and we're going to go through that now. And then there's also the consolidated reading list that you should have, or you should have been aware of this for this year since you've been a pupil, because the exams are based on these documents. So let me just start off with the first one, which is the notice. If you can have a look on my screen, I believe candidates can see my screen. You'll see this notice was sent to candidates about a week and a half ago, just with regard to what applies to these exams. First of all, you'll see on the first page, it deals with the format of the exams, what it is you need to know. So on the 11th of September, there's 2 papers that you'll write. The first one starts at 9. The second one starts at 2. The first paper is the motion court paper in information and communications technology. This paper you'll see there's reading time of half an hour. So you'll have half an hour to read, and then you'll have your hour to write the exam. The second paper you'll write on that day is your trial court proceedings and ADR. The reading time is 15 minutes for this paper, and then again you have your hour to write. The next day, the 12th of September, you have your criminal procedure paper in that morning starting at 9 o'clock. The reading time here is also half an hour. Your writing time is 1 hour. And then your fourth paper, the afternoon of the 12th of September, starting from 2 o'clock, is ethics, constitutional law, and customary law. The reading time there is 15 minutes and it's an hour to write. Remember, for those 4 papers, the marks for the exam, it's out of 50. And you need to get 25 out of 50 marks, which is 50% in order to pass those exams. Then your longer paper, this is on the 18th of September, the following week, and this is the legal writing and drafting paper. This paper you also have in half an hour reading time, and the writing time is 5 hours. So you know that for this exam, you'll need to draft. That's why we give you 5 hours, and that time is sufficient. Many of you may finish even before that time is up, and you're allowed to leave when you are finished the exams, but take your time and draft accordingly for that paper there. All right, so just a few other notes. For papers 1 to 4, you're not allowed to take anything with you into the exams at all. No textbooks, no materials, no precedents, no notes, no laptops, smartphones, tablets, or anything like that. Those exams, you just go in with your ID, your stationery, your registration letter, but nothing else to assist you in the exam. For paper 4, where we deal with the ethics section, you will be provided with the relevant part of the code of conduct. So we'll give that to you in the exam. You don't need to bring it with you. And then you'll obviously have to answer questions on that code. But you cannot bring anything with you for those 4 exams. So please, anything that you try and get in will be an irregularity, and you'll be removed from the exam room. For paper 5, this is the exam that you are allowed to take your books into the exam. So you'll see on this notice, it says that you cannot use a tablet, a smartphone, or a laptop during this exam. So please don't say that it's an e-book and you need to therefore use your tablet or you need your laptop in the exam. This is not permitted. It has to be a hard copy textbook. You must remember that the invigilators will be checking. There are less candidates who write these exams, so our invigilators will check every candidate with what you're bringing into the room. If you do try and bring in any handwritten notes or articles or any textbook other than the ones listed below, it will be removed from you and you may be removed from the exam room. Okay, so let's have a look at the books that you're allowed to bring in. Remember, you don't have to bring in all 6 books. We just give you the options because some people may have one and not the other. You can bring in one book only, and that'll be enough for you. Or you can bring in more than one. You're welcome to bring in whatever you think you need. But please remember that bringing in all 6 books is going to disadvantage you in the exam because you're not going to have time to scroll through 6 different books looking for what you need to answer the questions. So don't try and collect all these books to bring in. It's not going to assist you. If you want to bring in 1 or 2, that will be sufficient for the exam. Even 1 will be sufficient for these exams. So the following textbooks are permitted. You'll see it's Harms, it's the Amler's Precedents.
I was checking that.
Sorry, please mute yourself. Okay, so just to go through that again, the following textbooks are permitted and recommended. That's Harms, that's Amler's Precedents, Hussein's Practical Drafting Skills, and Marnovic, the Litigation Skills for South African Lawyers. Then, in addition to the above, you can also bring in these 3 if you choose, which is PT Civil Procedure Practical Guide, Joffrey's High Court Motion Procedure, and Erasmus Superior Courts. We do recommend the first 3, but if you don't have access to those, then you can use the others. But like I said, please don't bring in all 6. It's actually going to disadvantage you in the exam. And if you have access to 1, that is fine. The exams must be textbooks. You cannot bring in a photocopy of an entire textbook. That won't be allowed. Not just for copyright reasons, but we don't know if you've included notes or other documents in that printing, so it has to be a hard copy textbook. There won't be any textbooks in the exam to assist you. So when you get to the venue, we don't supply any of these textbooks, and you also can't share a textbook. In the exam, you can't be passing around a book. So please make sure that you have your own copy when you walk into the exam room. That is that is the notice that was sent out. That's everything I need to share with you on this notice. Are there any questions on these documents first before we hand over to Advocate T, who's going to take us through the next part of the presentation? Let me just quickly check in the chat if does everybody understand so far? If you can just give me a thumbs up. If you're with me, if you understand. Okay, so I'm just having a look in the chat. Okay, guys, write your questions in the chat box. We're not going to take hands. Please put it in the chat. So there's a question here. Can I bring in fundamental principles? No, only the books that are listed there. And vigilators have been asked to check that it's only one of these 6 books. So please check that you have those books. Okay, I see some thumbs up. That's great. Is Harms allowed? Yes. So on this list, you'll see there's Harms, there's Erasmus. You can bring in any one of those books that you want to. Yes, your books don't have to be clean copies. If you have got flags in the books, that's not a problem. But please, you don't need to write. Please don't write big stories in your textbooks. Please make sure they're as clean as can be, but it doesn't need to be a brand new textbook. That's fine. Okay, I think we've covered those questions there. So, all right, I think we've covered that. So, I see some candidates saying they didn't receive the notice. I'm glad we're having the session now because then at least we have covered that. You'll see that this is what we allow into our exam. So there's the list of books. You can borrow them. So if you've in your if you need to borrow books, please speak to your principals or speak to your bars. I'm sure they have books that they can lend you. We don't, unfortunately. Dictionaries, no, you don't. You can't bring dictionaries in with you. This is just for These are the books only that you'll be allowed into the room. We won't allow anything else to come in with you.
Hey, Melissa, my apologies, something I don't want to clarify.
No. Sorry, no. We're not taking questions at this stage. We're just only in the chat. Write it in the chat. And then we'll take questions. We're not doing interactive right now. I just wanted to see if there were any questions on this notice before we hand over to Advocate T, who's going to take us through the next part. So put your comment in the chat and I'll get to it as we go through. All right, so I think we've dealt with that. We will send this notice out again if there's candidates who haven't received it. I'm also going to put this document into the chat if I can, so that you can download it from there as well. All right, so thank you to everybody. I'm now going to hand over to Advocate T, who's going to take us through the next part of the session. If there's any questions that anyone else has, please can you write them in the chat and we'll get to them as we go. But please, I can see messages popping up. What about this book or what about that book? No, you can only bring in the list that's been given to you. And there's a reason that we use these books. Remember, we are trying to assist you. So books that you are recommending or that you're asking, no, it's not that we're trying to be mean. We're trying to assist you. And these are the books that will give you the best chance in the exam. So those of you who are asking about other books, the answer is no. Please try and bring in one of these books that we've recommended on this list, because that's going to give you the best chance going forward. All right, I'm now going to hand over to Advocate T. I'm just going to share Advocate T's presentation. Advocate T, can you unmute yourself so that we can hear you?
Do I really need to speak? Right, good morning, everybody. And Melissa, thank you for the introduction. I'm going to deal with 5 topics. And the first one is the purpose of the exams. The second one is the exam papers and format. The third one is preparation for the exams. The fourth one is practical assessments. And the last one is how to pass your entrance exam, and that's going to be the most important one. So if we go to the purpose of the exams, a lot of what I'm going to say here is a repeat of what Melissa has already told you. The purpose is to assess your level of competence to practice as an advocate. So the Legal Practice Act sets out the requirements of the competency-based exams, and that is read with Regulation 7.9, excuse me, which is read with the rules and read with the Code of Conduct. Now, just as a warning, the Code of Conduct, Section 60, often comes up in exams. I don't know if it's in the current ones, but make sure that you know Section 60 of the Code of Conduct. Read it long before you get into the exam. Okay, exam papers and format. There are 4 one-hour exam papers and 1 5-hour exam. Now, the reason why we do it this way has a history. Before the Legal Practice Council came into existence, there were 2 main professions, the attorney's profession and the advocates. Amongst the advocates, pupillage was done and conducted, and the pupillage exams were conducted under the auspices of the General Council of the Bar with their own National Bar Examination Board. So traditionally, the way advocates operated is they had 4 one-hour papers and 1 8-hour paper. The 4 one-hour papers were motion court, trial court, criminal procedure, and ethics, and then the legal writing was an 8-hour paper. Now, the worst part of the 8-hour paper was to try and get lunch. Luckily, with the 5-hour paper, if you eat before, you can starve yourself till the end of the 5-hour paper and you'll be okay. Now, When the Legal Practice Act was passed and the regulations passed, Regulation 7.9 is the key. And you will see that because the tradition had been motion court, trial, criminal procedure, and ethics, there were more subjects that needed to be dealt with. And so those were added together, as you see in that document there. Motion court was attached with information and communications technology. So that's why those two regulations are combined into that paper. The same thing happened. There were 3 regulations that were combined into trial court. Then criminal procedure stayed on its own, and then ethics had 2 to be bound into it with it. Now, most importantly, when you do these exams, you will note that you get reading time. So you've just seen the exam format. That exam format shows that traditionally you get 15 minutes to read, and then you have an hour to write a 1-hour paper. But as soon as you see that you're getting half an hour, it means there's a bit of extra reading. Now, I'm not sure why they've got extra reading for 2 of the papers, but it must necessarily mean that either you're getting a statute to deal with, or you're getting a case law to read, or something like that. It depends on the way in which the examination was set. The next thing you need to know is there is a pass of 50%. So if you get between 40 and 49, that earns you the right to an oral examination. If you get below 50%, it doesn't matter, your paper will be moderated. So even if you get below 39, if you get below 40%, you're going to get, your paper will be moderated. As pupils, you also have the right to a remark. And then some practical things I just want to point out. Handwriting plays as much an influence in marking as does the use of language. And that's really important. If your handwriting is neat and easy to read, then the examiners, by virtue of being human, they will find it easier to mark your paper. And then I'm going to deal with English language later. It is important to write as clearly as you can in English. Right, let me go to the preparation for the exams. Now, the key is the June 2021 LPC reading list. Now, I'm not sure if, Melissa, you could put the LPC reading list, if you could share it at this moment. But the bottom line is this. If it is not in the reading list, it will not be in the exam. However, if there is an extra case or statute to be added, then you get extra reading time. So from the format which Melissa showed you right at the beginning of the document she sent to you, it is quite clear that at least 2 papers are going to have something extra, which is why you're given an extra 15 minutes to read. Use that time profitably. Make sure that you really do read that question. Are you battling to find the reading list, Melissa?
No, I have it. It's just sharing. Just give me 1 sec. It's just busy uploading here.
Thank you. I'm going to be asking you to scroll through it once it's up. Now, the reading list is available on the internet, so it's not a document that has been hidden away. And hopefully, all your training supervisors, sometimes colloquially referred to as mentors, and in the olden days referred to as masters, I hope that they've been insisting that you go through the reading list step by step, even even when you're doing your pupillage. It's important to do that because there it is, perfect. So the reading list is important because it is based on the norms and standards which were published by the Legal Practice Council in December of the year 2020. So the norms and standards inform what you have to read, and you are obliged to read in the reading list. So in the first part there, you will see that deals with motion court. If you can scroll down a little bit on this one. You'll see there are lots of subtopics, and in these topics, you will be able to read what is necessary. And it refers you, let's give an example. If you can make it a little bit bigger. Let's give an example of Culane versus Tiger Food Industries. What you have to read is at paragraph 12. So you don't have to read the whole case. So you must focus in on that reading list and read what is in the reading list itself. Now, the reason for the reading list is the following. Apart from getting it as a very important tool to examine people to see whether you will be good enough to pass the competency-based exams to practice as an advocate, you will be able to use that reading list for the rest of your practice, for the rest of your life. All you have to do is to keep updating it. And you update it in particular with case law using the annotations. And every couple of years, and I believe the Legal Practice Council is soon going to be publishing an updated list for 2025. It's open source. It's on the internet. You will be able to download it. And it doesn't matter if you're specializing in criminal work, you would be reading the reading list on criminal. But if you're specializing in motion court, you would always be able to keep up to date on that. Can you scroll down to the criminal one, please, Melissa? That's the trial court. And here's criminal procedure. Right, if you just go down the next page, you can see that the criminal procedure is set out where you have to look at specific aspects of the Constitution. So you're not asked to read in this section the whole of the Constitution. You are focused into reading particular sections. Now, of course, this is a 2021 list. So if questions are based on something that is newer than the 2021 list, you will probably be given the case or the statute, and that's why you'll get an extra few minutes of reading time. Thanks, Melissa. That's enough on the reading list itself. Now I want to go to the fourth part, which is the practical assessments. Now, the reason why these are practical assessments is the first point to notice is that this exam that you're writing is not a rehash of your LLB exam. In fact, the way in which the setters of the exam put the exam together, the very process of writing the exam is part of your learning curve to enter the profession. And it's very important to understand that. You are writing the exam so that you can show the examiners that you are actually competent enough to be an advocate. But inside the exam questions, sometimes, particularly if you've got extra reading, you will find that it's done on the basis of an important statute or an important regulation or an important court case, which will stand you in good stead in the future. The second thing about it is that the exams each script is marked objectively and to the same standard. So what the Legal Practice Council does is it gets together templates. These templates for the answers. So all the examiners work off the same template. Now, a template is not a precedent, and a template is not a model answer. A template reminds the examiner to look for certain things in the answer. Did the pupil spot that legal principle, yay or nay? Did the pupil, for example, remember that there are 4 elements to a delict? Did the pupil remember that they have to put in, even if they're told that there is a case that is based on a contract which is written, has the pupil remembered to plead that the contract has been attached in terms of Rule 18? Those are the sort of things that the templates do to remind the examiners. And then even the examiners, they too are subject to moderators. So after the examiners have given a mark, they will be subject to moderation, and that is also provided for by the Legal Practice Council. Okay, that is why you're going to get a very fair assessment. Now, you're expected to draft in a way that is logical and easy to understand. And I'm going to come back to that with regard to language in particular, but the most important thing about drafting, please remember to draft chronologically. Once you've introduced the parties, do it what they call sequentially. Draft logically, draft sequentially, so that the story unfolds in your pleadings. These are really important. When you're answering difficult questions like opinions, keep it logical and keep your assessment, keep it in a way that it is able to be reasoned. And reasoned means that you demonstrate your ability to reason and to solve a problem. What the examiners are looking for is in that underlined portion. Can you deal with the substance of the problem? Do you actually see what is going on? Do you grasp the concepts and the principles relevant to the question in the exam? Can you analyze those legal issues? Can you apply legal principles to the facts? And can you evaluate different arguments? Now, the subtext of what they do is this. Is your answer organized? Do you use clear language? Do you present your ideas logically? Do you reach reasoned conclusions? This is the stuff of law. The entrance exams require you to apply established legal principles to the facts of a case. However, examiners will also reward legitimate originality and creativity in the application of those principles. So sometimes they like novel arguments and legal and solutions to legal problems. I'll give you a very practical example. When you asked, for example, to do a plea in accordance with Rule 22 of the High Court, and then you see, but in you pleading to some particulars of claim, and you've read the facts carefully, and you say, but hang on a minute, one of the parties is missing from this case. So you've been asked to put in a plea, but you put in a special plea of misjoinder or non-joinder, and then you plead over, which you have to do because otherwise you're not going to get any marks for your exam because you were asked to do the plea. But the cleverness of putting in a special plea, which was not asked for, but which you gave because you could see there was a gap, shows that you understand the practice of law. Now that gives you bonus marks in case you do badly in other questions. Now let's go to the language issue. Let's put that a bit more into the page. Lord Denning said, to succeed in the profession of law, you must seek to cultivate command of language. Words are the lawyer's tools of trade. In South Africa, despite our 12 official languages, remember we don't have 11 anymore, we've now got sign, which is a 12th. The problem is English plays a disproportionately important position in law. Now, the overwhelming majority of people in this country who are doing entrance exams, be that for attorneys admission or advocates, do not speak English as a first language. And that, frankly, puts a lot of you at a lot of disadvantage. And I'm not sure how we're going to be able to address that at the moment. But I do have some clear ways in which you can bypass that difficulty. I use it: overcook. Don't overcook your English. Don't try to use fancy jargon words where you're not quite sure of their actual application. Write in plain English. The shorter the sentence, the better. Drop the idea of using and where you're linking two sentences. Write one sentence: the dog ran away. The cat chased the dog. Don't write the dog ran away and the cat chased the dog. No, that's not worth it. Keep it short, to the point. Okay, now let's go down and I'll show you how examiners use the following approach for dealing with language. They do not worry too much about spelling. Grammar and syntax always take second place to content. Good content written badly is better than poor content written well. And I want you to focus on that one. Good content written badly is better than poor content written well. So don't think that just because the person speaks a very slick English that they're talking sense. Remember, there are lots of people who are very gifted with the gab, but what they say is not very clever. So remember that middle line there, it's important. And so you must concentrate on the content of your answers and concentrate on substance and not style. I've put in that line there: with legal writing, consider writing concisely, accurately, and persuasively in a way consistent with legal practice. Try to keep away from the wherewithals, the hearings, and so on. Okay, now here comes the most important part. This will tell you how to pass your entrance exam. Okay, there are three main steps. First, I suggest you apply the mark a minute approach. Now, when you're dealing with the first four exams, technically the 1 hour writing you've got, each of those exams is worth 50 marks. Now you've got 60 minutes. So it's a mark a minute. It's a mark a minute. You're earning a mark a minute. And then you've got 10 minutes to review. Now, with the 5-hour exam, you've got 300 minutes. Okay. So you must decide what percentage you are going to give to each of the questions. So sometimes in the writing exam, there are 4 questions. Sometimes there are 3. But each question will have an allocation of a mark. Can you go back a bit, please? Each question will have a mark. Right, stop there. Now that mark, you must notice the 5-hour paper is out of 100 marks. So if there is a question for 20 marks, then you know that's 20% of the exam. If there's a question for 40 marks, you know that's 40% of the exam. So you must look at which questions will reap you the best reward, and you must allocate your time on that basis. Okay, you already have the exam format. So what they used to do, and it might come back next year, is they would actually put in the exam format how many questions you have to face, but I see it's not in the exam format this year, which means that it follows the exam formatting where attorneys don't know how many questions are going to be in each paper. So I understand that there has been a measuring that both attorneys and advocates need to be examined on the same fair system. All right, the second thing, and this is the one that is the big bugbear. You have to answer the question that is posed, the question that's asked. It's, again, it's an entrance exam, not an LLB. Answer the question. Do not answer what you think the question should be. There's an example that I've put in there because I saw it from one of the papers many years ago. The question was, do a section 112 plea of guilty for murder. And the person wrote a magnificent plea of culpable homicide. And I think it was for 20 marks and got naught because they didn't answer the question. So you are not there to tell the examiner, listen, you set the exams badly. I prefer to answer my question. So you must give me marks on the basis of what I've asked, what I've answered, not what you've asked. Okay, the questions are posed to assess your analysis of the facts. And here's another one. In the old attorney's papers, you were allowed to put in your own facts. In these exams, you are not allowed to. Do not make up facts. Do not add. Do not pad. Indicate missing facts that you think are missing in square brackets, to be obtained or to be informed or whatever. Made up facts are classified by the examiners as false facts. False facts are the road to a failure in practice and in the entrance exam. Now, here's a silly one. I know you're not allowed your cell phones or your smartphones in the exams. But if a question says, last Friday, now if you are writing today, the 28th of August, then last Friday, you have to work it out. Last Friday will be the 23rd of August. So don't put in a pleading last Friday. Put in the date. Work it out. If you have to draw a little calendar to work out the date, work it out. Don't make those sort of silly mistakes. You plead the actual date. Now, Rule 18 is very important. It requires you to number the paragraphs. Under no circumstances, under no circumstances do you number the headings. The headings, rubrica non est lex, headings are not part of the law. You are there to abide by Rule 18. You number the paragraphs. You can put a heading in, which is a good idea. It signals to the examiner that you know what you're doing. But please don't number headings. Number paragraphs. Now, you've got to read Rules 18 and 22 of the Uniform Rules. You've got to know them as best you can, ideally almost off by heart, but normally you get them in an exam. And I want to tell you an amusing thing that happened apparently in a couple of exams ago. It related to a question on Rule 18.1. Now, Rule 18.1 allows an attorney who has the right of appearance, in fact, it doesn't allow, it requires an attorney who has the right of appearance to sign the particulars of claim alone, without an advocate. Let me say that again. Rule 18.1. It requires an attorney with the right of appearance to sign the pleadings alone without an advocate. So the question revolved around whether or not, because in the question it was said that the attorney and the advocate had signed the plea, was that irregular? And of course, when people read the rule, then they worked out, oh, yes, it is irregular. That is the level of detail that you need to know. And the reason why I'm highlighting that is Judge Owen Rogers, he wrote an article on the hopeless case. And it's really important to read it. It it's in the reading list. It's right at the beginning of the reading list. In fact, it's mentioned a couple of times. Read that article by Judge Owen Rogers and make sure that you understand it in the context of Rules 18 and 22. That is a prize question. It's asked so often. And you can test yourself by going to that website and looking at the past papers. And then once you've looked at those past papers, come back to this document, because I'm sure that Melissa will be able to share it with you again. And then look at the way the questions are set, and then look at this document and then see whether you like the approach that is used. Okay, that's it. The final tip that I have is one that I always tease people about. It's do your best, crib the rest. Oops. I mean, keep a sense of humor. Now, inside those exams, I've noticed that the setters often use a sense of humor. So what they're trying to do is they're trying to make you laugh while you write the exam. So, for example, the attorney comes to you and he's worried. And what's the attorney's name? Mr. Katazega. Why is that? Well, that's worry. Then you get a firm of attorneys using the English names, Dewey, which is D-E-W-E-Y, and then Cheatham, which is C-H-E-A-T-H-A-M, and Howe, which is H-O-W-E. But strung together, it reads Dewey, Cheatham, and Howe. Now, if you're clever, you'll laugh because you could see the examiner has a sense of humor and they're wanting you to laugh. And the reason is it's part of the very didactic, the teaching method. The purpose is to make sure that while you're writing the exam, you find some of those questions amusing, it relaxes you, you write better, and you will succeed much better. So I wish you luck, and don't crib the rest, but do your best. Thank you, Melissa.
Perfect. Thank you very, very much for that, Advocate T. We really do appreciate you sharing all of that with the candidates today who are writing these exams. I'm just trying to see, it's not letting me add these documents into the chat, so we're going to just have to try and email it to all candidates who are registered for the exams. You can also just send me a mail and I can then just send it to you. So that would be that consolidated reading list, as well as the notice that had the textbooks that you're allowed to take in with you. If you missed anything today, this session will be published on YouTube, so you can go back in and listen. The reading list, for those of you who've mentioned that you might not have received the reading list before, remember the training that you've done through your bar council or through an accredited training provider is aligned to this reading list. So don't panic if you're looking at the document now thinking that you might not have seen it before. This you would have seen before because you would have covered all of this in your PVT training. So please don't stress. Print out a copy of this reading list, go through and tick each of the topics to make sure you've covered them. We do have a little bit of time to take some questions if there are. So I'm just going to have a look through the chat here. If there's any questions, if you can just put them in the chat. So we have answered here. If you don't have the documents, I'm going to put my email in the chat so that you can email me. It's melissa.m@lpc.org.za. But we're also going to email this to all registered candidates. So please, if you don't get it within the next day or two, then please then email me. But I am going to ask my team to send out this email to everyone during the course of today. So you don't all have to email me right now. Just give me a little while. As soon as it is emailed out to registered candidates, if you don't receive it during the course of today or by tomorrow morning, then please email me. Let me just have a look at some of the questions. Please, when adding a case number and pleading if it was not given, you don't need to add in case numbers or the case citations. If you are referencing a case, you will get the marks for just knowing what case is being referred to. There's a few questions here with regard to the book, but I can see we've covered a lot of those. Okay, someone said the confirmation is an email. Yes, if it's an email that was sent to you with the confirmation of your registration, then just print that email. So it might not be a letter on a letterhead. If your confirmation was sent to you via email, but it has your exams, what you registered for, your exam number, then just print that email. And then that will serve as your confirmation of registration. So Raymond, I hope that answers that. Okay, we've covered the reading list, the emails. Yes, print that email and bring it in with you. This notice will go out today. And I think that's covered everything here. Okay, so let's have a look if there's any other questions coming through. No, we don't recommend that you bring snacks into the exam. I know it's a long paper, but eat a good meal before you go in, and then you'll manage for your time. So no, you can't bring meals in with you for that exam. But candidates have written these exams before you, and they've all managed. Like I said before, your textbooks, if they don't need to be brand new textbooks, but we do recommend that they look as clean as possible. So if you do have sticky notes or anything sticking out of the books, we do recommend you take those off. Remember, the invigilator is going to be looking through your books. So just make sure if there's writing in it, it's not going to be an issue, but just make it look as clean as possible. If you haven't, Chapiso is asking me if you haven't received confirmation yet. What does it mean? Just follow up with the provincial office. You should have received it by now. Because the exams are to be written in 2 or 3 weeks' time. So please just follow up with your province. You can always email me if you want us to just also have a look on our system. So I know you've got my email address. You can send me a mail. Okay, is there a possibility to access past papers? Yes, if you go onto the LSSA website, because remember before this session, the exams were being facilitated by the Law Society. So you go onto the LSSA lead website, and if you go onto candidate legal practitioners and past papers, you'll find some past papers there. These papers are only for you to practice. Please don't learn the questions and think that's what's coming out in the exam. We also do not give previous memoranda or model answers, as candidates would call them. That's because especially in these advocates exams, there isn't always going to be one right answer. For example, if you have to write an opinion, you're going to find that candidates write very different answers, but both may be equally correct. So you need to just make sure that you've covered. Sorry, I'm just checking that question there. So you need to make sure that you've covered the question, you've answered as fully as you can. But remember that candidates may write different things and get the marks for those questions. So you're not going to find a memorandum or a model answer for any of these exams. If you want to practice and use previous papers, you're welcome to do so, but only the question papers.
Melissa,
the memoranda won't help you. Yes, sure. Jump in.
The website is in the document that I've sent you, which you're entitled to share with the pupils. It's under third, test yourself against LPC past papers. That's the LSSA website, and they can just click on that and go to those papers.
Perfect. Thank you so much. And I see one of my pupils here has put the link in the chat as well. For those who,
well done.
So you're welcome to, but candidates, you're welcome to look at past papers, but like I said, don't rely on them. And also don't look for memoranda or model answers because there aren't any and you won't find them. Okay, the last question here, I can see that just popped up. Should we cite cases for legal writing? Let me ask Advocate T if he can maybe help us here. For the legal writing exam, are candidates going to be expected to cite cases? What do you think about?
Yeah, the best way to deal with that is you've got to be able to show that you know the principle of a case. You can certainly cite the case, even if you don't have the full citation, because remember, in practice, when you're drafting, you will have the books right next to you, or you'll have Tutorstat or Tutor Evolve, or you'll have LexisNexis. So when you're actually doing real drafting in real time as an advocate, you will have access to those citations. So you don't have to worry if you can't remember the whole citation. That's why I say you can say this case and then square brackets detail to be filled in later, because then we know that you know about it. Focus on the principles and make sure that you apply the facts, the principles to the facts of the case. There is a mantra that is used in training, especially for lawyers: facts first, law later. Okay.
Perfect. Thank you very, very much. I hope that answers that question. So you do need to just know case names, especially when it refers to principle, but you don't need to include the whole citation there. Are you allowed to make notes on your question paper during reading time? Yes. You cannot open your answer book and start writing until the reading time is over. But yes, you can make notes and write or highlight on your question paper during reading time. So make the most of that time. Use those 15 or 30 minutes as part of the exam. Take your time, read, highlight, so that when your reading time is over and your time for writing the exam begins, you know you're good to go straight away. One other thing I should have mentioned earlier, you don't have to answer the questions in the order that they're given to you in the question paper. So for example, if there's 3 questions, you can answer question 3 first and then question 2 or question 1. Do it in the order that you feel most confident. So you don't have to strictly stick to the order. You're welcome to start with 1 and work through the paper if you're happy to, but you don't have to. But make sure that if you start with question 2, on the top of the page, you write the question 2 so that the examiners know exactly what question you're answering. We won't be able to guess. If you write question 1, but then you answer question 2, unfortunately, you'll get 0 marks for that question because it just looks like you don't know what you're talking about for that particular question. So you're welcome to answer in any order you want to, but you don't, but you need to be clear about it. Then the next question I've got here, a recording. Yes, go onto YouTube. Either later today or tomorrow morning, you'll see the session will be there. Go to the Legal Practice Council page. We post a lot of content there. I also recommend that you like our social media pages so that you can always follow information when it's posted there. So that's YouTube and Twitter. Our communications team does try and get information out there quickly. Then also, okay, should you cite cases? You don't need to use footnotes. You can just cite it in the body of your answer. In the text is perfect. That will be fine. Okay, the next one, are differently abled candidates provided? So any differently abled candidates should have already made contact with the provincial office and should have made an application in order to be properly accommodated for these exams. So if you have any challenges, this should have already been dealt with, and that goes through the provincial office. Mandla, are we allowed to have highlighters? You can highlight, you can bring in your highlighters. You just highlight your question paper only. So in your answer book, what you're going to hand back to us, we only want to see black ink. But you can bring in whatever you want to write on your question paper. You can highlight there, you can scribble, you can make notes. that's fine. So highlighters are fine, and we recommend that you bring in a highlighter or two, especially if you've got a bit of extra reading time. You know there's going to be something that you need to read in addition to the question. So yes, have a highlighter with you. We're not going to confiscate it from you. All I'm saying is that with regard to your question paper, it must only be black ink in that question paper. Sorry, in that answer book. But on your question paper, you can put anything there. Cheryl asked, we can only bring in textbooks for legal writing? Yes, Cheryl, paper 5 only, nothing for papers 1 to 4. Okay, and I think that takes me to the end of all the questions here. I can see I've addressed all of them that have popped up. All right, so everyone, as you know, you can email me if there's any other queries that pop up. If you haven't received your proof of registration at this stage, I suggest you very quickly find out that you are registered and make sure that your seat has been booked for this exam. If you arrive at the venue without that proof of registration or without your ID, you will not be allowed in. And there's nothing that I can do to help you on the morning. We cannot verify that it's you. You cannot be allowed in. So remember those two things, please, an original ID and that confirmation, either a letter or an email that was sent through to you. Then just as we discussed, write in black ink, no typics, write on the one side of the page only. We are going to send out these documents to all registered candidates, so you don't need to email me right now if you haven't received it, but you can send me a mail by tomorrow morning if it hasn't come out to you just yet. I think I've answered everything. If there's any other queries that pop up, you can ask me. Just not what is coming out in the exam, because that I can't help you with. But if there's anything regarding logistics or what you need, please just let me know, and I'm always happy to assist. I think all that's left for me to do, first of all, is to thank you all for being here. Thank you for your time, for coming in and joining us for this session. I also want to thank Advocate T for giving his time to be here today as well, to give you this information that you need. I'm hoping that a lot of you feel a lot more confident, that you're able to go into these exams and do well. And we do have candidates who pass all 5 exams at the first shot. So don't worry that you might not pass all. Every sitting, we do get a lot of candidates who pass all 5 exams. If something happens and you don't pass one, or on the morning of the exam you're not well and you don't arrive for the exams, then you'll register for the exams next year, which will be in April 2025. So there is no limit to the number of times you can write these exams, but please try and pass on the first or second time. We don't want to keep you in the system for too long, and I'm sure a lot of you want to start your careers as advocates as soon as possible. So from my side, it's really just to wish you all good luck with your preparation, and good luck for the exams. You all know a lot more than you think you do. So please don't let the anxiety and the stress take over. Be calm, be confident. You know what you need to do. If there's any questions that you have, you're welcome to reach out to me. But at this stage, I just want to wish you all well. And hopefully after the exams, I'm going to get a lot of messages, a lot of excited candidates, knowing that you've done the best that you can do, and you're confident that you're on your way to be admitted as an advocate. So thank you, everyone. Thank you for your time, and I'm sure we'll chat soon.
Thank you, Melissa.
Thank you, Advocate T, and thank you to everyone. And our session is adjourned. Thank you.